Welcome to FERPA and What You Need to Know, an Educator's Guide. What is FERPA? FERPA stands for the Family Education Rights and Privacy Act. It is also sometimes called the Buckley Amendment. It is a law that was enacted by Congress in 1974 and amended again in 1994. Well, now that we know what it is, what does it do? It protects the confidentiality of student records and keeps identifiable information about students safe. What are a school's responsibility when it comes to FERPA? Schools must provide students and parents a copy of the FERPA policies and procedures used by the school annually. Schools can lose their funding if they deny parents access to their children's school records. What should the notification that schools give include? Well, first of all, it should tell the parents that they have the right to inspect and review their children's education records. It should also tell them that they have the right to seek corrections if they see anything that needs to be corrected. There should also include a consent to disclose personally identifiable information, also known as directory information. It should also tell parents that they have the right to file a complaint. Additional information that should be included in this notification are the procedures for viewing records should parents decide they want to see them, procedures for requesting amendments if they see anything that they don't like or that they feel is incorrect, who constitutes a school official and what constitutes legitimate educational interest. What information is covered by FERPA? Educational records. This includes records, files, and documents that relate to a child's educational experience. There is some information that schools are allowed to give out. What information is this? Schools may give out directory information, but students and parents must be given opportunity to opt out. This should be included in your information about FERPA policies. So what are the rights of parents under FERPA? They have the right to inspect school records with school personnel present. They also have the right to challenge accuracy of any information contained in those records. Sometimes, in the case of divorce or other situations, non-custodial parents may want to have access to a child's records. Sometimes this is contested by the custodial parent. In one court case in New York, a district court ruled that neither parent should be denied access to a child's educational records. So for non-custodial parents, it really depends on the state. The rights of eligible students. First of all, who are eligible students? Eligible students are students over the age of 18 or those enrolled in post-secondary education. And they have the same rights as parents. They can review their records at any time, and they have the right to file an amendment or file a complaint. This also means that parents do not have access to these records unless specifically given permission by the students. What are the rights of school personnel? Those with legitimate interest in education records may view them. This means principals and teachers and anyone else who has a vested interest in a child's education. Each viewing must be well documented with initials and dates. In 1994, FERPA was amended to include disciplinary records. Enforcement of state and federal statutes. State and federal agencies may view records when appropriate with parental consent. Reasons that state and federal agencies may view these records are things like reviewing the effectiveness of a program or a school. In most cases, personally identifiable information such as name are not included when these agencies view the records. Defamation by school personnel. Defamation is false statements made about another person with the intent to harm the person's good name and reputation or subject the person to hatred, contempt, or ridicule. There are two types of defamation: slander and libel. Slander is oral defamation, whereas libel is written defamation. So with slander, it is if a teacher says something about a student, and libel is if a teacher writes something about a student, such as in the student's records. So teachers have to be very careful about what kinds of things they say and write in regards to each of their students. There are some ways that school personnel are protected under FERPA. Those personnel with privilege, personnel who act in good faith, and when it is deemed there was no malicious intent. In these situations, school personnel are protected by some states. If it is deemed that school personnel had the privilege, such as the teacher, to review the records of a student, they acted in good faith, and that they had no malicious intent. Confidentiality of school counselors. Protection under state law is different state by state. Counselors are not required to share any information with parents. But confidentiality can be lost when disclosure is in public interest. In the case that I have cited here, a school counselor was told by another student that he was going to kill a student, gave the name and everything. The counselor did not act on this information, and the student was subsequently killed. And the parents sued the school, saying that she should have been warned so that they could have taken precautions. So now, when a counselor has information that may be in the public interest, they are required to disclose that information. Here are some quick guidelines. Schools should have policies in effect that help protect student information. Accurate records need to be maintained at all times, and any corrections and adjustments need to be accurately documented with name and date. Teachers and other school personnel should avoid labeling children. Information regarding discipline should be specific, with the incident, who witnessed it, date, and name of students involved cited in the information. Avoid aimless chattering gossip. Records should be kept in a safe and secure place with limited access by those who do not need access to it. Non-custodial parents should have the same access of custodial parents unless prohibited by a court. Avoid releasing information over the phone. It's hard to establish a person's identity over the phone. Public disclosure of grades will not be supported by courts. All information in this presentation was taken from A Teacher's Pocket Guide to School Law by Essex. Thank you.